Good afternoon, everybody. I am Mel Underbaki, the Deputy Executive Director of the Coalition for Civil Freedoms, and this is episode 23 of our webinar series. This episode is also part of our annual family conference, but it's being streamed live on Facebook and on YouTube. If you have any questions while watching this, you can submit them in the comments section on Facebook, and we'll try to get them answered. The title of this episode is Prisoner Releases, Analyzing Hopeful Trends in the Courtroom and on Capitol Hill. We'll be hearing from our legal director, Kathy Manley, CCF board chair, Steve Downs, and also, we're happy to say, from Molly Gill, the vice president of policy for atFAMM, which is a nonpartisan, nonprofit sentencing reform organization in Washington, D.C. I'm just going to read a part of her bio. She's a lawyer, advocate, and expert on sentencing law and policy with almost 15 years of experience working in the criminal justice field. She coordinates atFAMM's sentencing reform campaigns in states across the country and works with state lawmakers, affected family members, and other criminal justice stakeholders to promote sentencing and prison policies that are cost-effective, protect public safety, fit the crime and the individual, and preserve families. Gill has also served as a commissioner on the District of Columbia Sentencing Commission, and she is also a musician. I'm going to start with Kathy. There have been some good things happening lately. So I wonder, Kathy, could you tell us about some of those, please?
I will try to do that. Thanks, Mel, and hi, everybody. Yes, in the midst of all the bad news, with COVID ravaging the prisons and the virus of preemptive prosecution still going on, new unfair cases all the time, I wanted to show some of the positive signs I've seen with our cases. They range from people winning new trials and being released, people getting resentenced and released early, to people winning compassionate release motions because of a new law called the First Step Act. And finally, to people getting lower than expected sentences in the first place because they're lucky enough to have a good judge. There's also some hopeful signs on the horizon that Congress may pass more criminal justice reforms. Molly and Steve will talk about the congressional stuff, and I will focus on what's been happening in the courts and with people being released. So first, one hopeful trend is simply people finishing their sentences and being released to live peaceful lives. Now, that might not seem like a hopeful trend because these people had to finish their whole unfair sentences. But as more and more people have been released, it shows that, as we've been saying all along, these folks are not dangerous. I made a table of about 50 people who were released after serving 10 years or more on a so-called terrorism conviction and who are living here in the US or in some other country without any indication that they pose any kind of threat. And there's a lot more people who were released after serving shorter than 10 years. So there's a lot of people that were convicted in these cases and released and are not threatening anybody. So there's a couple of cases where people won new trials and then were released with no charges, no conviction. One is Uzair Paracha. A couple of years ago, he won a new trial because the evidence against him was based on tortured confessions from people who were held in Guantanamo. But even after he won that new trial, he sat in prison waiting to see if the government would actually retry him. I'm happy to say that last March 2020, his attorney, Ramzi Qasim of Clear, who's a member of our coalition, managed to negotiate with the government to get all of the charges dismissed and get him sent home to Pakistan, where he's there and he's doing well, as far as I know. Many congratulations to Uzair and Ramzi. Another person who won getting their conviction reversed is Hamid Hayat. He sat in prison for many years, even though he was completely innocent. But thanks to his attorneys, Dennis Riordan and the rest of his team, Hamid won a new trial in 2019, and he was released in August of that year. Then in last February 2020, his charges were completely dismissed. We in CCF were very happy to have done a webinar featuring him and two of his attorneys who explained how they won his freedom. And you can watch that, it's on our YouTube channel. So there've also been several victories in cases where people were serving long sentences, sometimes life sentences, and have been released. The Virginia paintball case is a good example of that. Some of the people, one released. Safala Chapman and Masood Khan, I probably mentioned last year that they actually were released from prison in 2018 after their firearm convictions under a section called 924C. Those convictions were vacated due to some Supreme Court decisions, which said that under certain circumstances, that charge is unconstitutionally vague. And since then, there's even more good news for them, because without that 924C charge, they would have been out years ago. So they served more than they should have, which isn't good news. But the judge then terminated their supervised release. So they're free with no conditions, which is great. And more recently, and this is amazing, on August 18th, 2020, we were thrilled to see that Ali Al-Timami, who is also caught up in that case, he was sentenced to life and was under SAMs, which special administrative measures, which means no contact with anybody in the world, basically, except for maybe one or two close family members and his attorney. And even then, it's very limited. He was under those crazy conditions. He was actually released on bail pending appeal, both because he has a good chance of winning his appeal due to changes in the law, and also due to his risk from COVID. So he was released, and that was in September 1st, 2020. He was released after he did a quarantine. So him being released also shows how absurd the government's position is, because they were arguing he can't even communicate with anybody in the world. He's buried under, 1 million feet of concrete and prohibited from communicating with anybody. And now he's just out. He still has a case pending, but he's just out now, and it's fine. He doesn't pose that kind of risk. He doesn't pose any risk. And then there are some people who had better outcomes than usually happens in these cases, initially in their case, or early on in their case. So one is Adam Shafi. He had a trial on terrorism charges, and the jury was deadlocked. So there had to be a new trial. And at that point, he was offered a plea deal to non-terrorism charges, and the government still tried to lock him up for 10 years. But the judge instead sentenced him to time served plus 6 months house arrest in 2019. So he got out. And an article about the case at that time quoted Hamid Hyatt's attorney, Dennis Reardon, as saying that compared to the fear-filled environment for many years after 9/11, there's definitely a different climate in these cases. And I will say that it depends on the judge, but some judges are losing that fear, which is great. Let's see. There was another case, Sinmaya Amara Caesar. Now, she was not even on our Ramadan list, meaning that she wasn't one of the people that we have chosen to support because we felt that the case was particularly unfair. She was an actual ISIS recruiter, and who had been working with ISIS for quite a while. But Judge Weinstein in New York went against the recommendations of the government, who wanted her sentenced to 30 to 50 years, and he sentenced her to only 4 years, saying, is it necessary to destroy this defendant in order to assure an appreciable increase in security? And she got released last July. So here's somebody who was an actual terrorist compared to our people that we support, who were entrapped in sting operations and otherwise unfairly convicted of terrorism. Now, I think that sentence was more in line with what would be fair for her. But, we see people who are completely innocent in our cases getting life sentences sometimes. So she was lucky to have this good judge. Unfortunately, he retired. He was 98 years old, but hopefully other judges will follow the kind of thinking that he did. We did have one somewhat positive appeal decision. Usually the appeal decisions are even worse than the trial court decisions. This is a man named Tyrod Pug, who struggles with severe mental health issues and was convicted of trying to travel to Syria, even though he had no contacts with anyone in Syria or in ISIS. In May of 2017, he was sentenced to an extremely harsh 35-year sentence by running his sentences consecutively. There were 2 charges and they stacked them together. And then, for what I think is the first time in a terrorism case, the Second Circuit Court of Appeals in New York found in August 2019 that this sentence may be too harsh, saying that the court didn't adequately justify such a long sentence. So now he's going to be resentenced, which has been delayed, right? Because it's been since August 2019 and he hasn't been resentenced yet. So we'll see what happens with that. I've actually been in touch with him and offered for CCF to write a letter in support of him. And he also may be filing a compassionate release motion, which brings me to the First Step Act and compassionate release. So in the end of 2018, Congress passed the First Step Act, which we had actually lobbied for after our family conference in 2018. And it got passed very soon after that. For our purposes, the most significant thing about it is that it now allowed people to file motions for compassionate release in the court where they were convicted. Judges had been starting to grant these motions in 2019 and release people, usually based on old age and very serious medical conditions, but occasionally for other, what they call extraordinary and compelling reasons. And then when the pandemic hit, people started filing for compassionate release based on the fact that they were particularly vulnerable to COVID-19, that it could be more likely to kill them due to their age or certain medical conditions. And thousands of those motions, well over 1,000, maybe Molly knows the exact number, have been granted since March. And we, wanting to protect our people vulnerable to the virus and also take this opportunity to try to get them released, we put together a list of prisoners we support who are over 65 and may have medical conditions making them vulnerable to the virus. And then later we learned of some younger people on our list whose medical conditions put them at great risk. And we filed about 10 or 11 motions so far. 7 of them were denied and 1 is awaiting decision, but we were thrilled that 2 of them were granted. The first one, as you may know, was Sami Hassoun. Last July, Amit Gupta won the motion that he filed for him. Amit is our other staff attorney. Sami Hassoun is a young man with a serious autoimmune disease who was entrapped in a very unfair sting operation in Chicago and sentenced to 23 years. And he had served a little less than half of that sentence when his motion was granted. Now, unfortunately, he's been in ICE detention since then and was supposed to be on a flight last Tuesday, but then he actually tested positive for COVID. Thank God he's still asymptomatic and hopefully he'll be okay. I think I'm about to file a habeas petition to try to speed up him being sent home or at least get him released on bond in the meantime, since his flight was postponed. So the other motion that we won was for Hawel Hassan. That was last September. And Salah Muhyiddin and I both worked on it. Salah is Yasin Arif's son. Yasin is my long-term client who's innocent and was released after spending 15 years in prison. Salah is now at Harvard Law School and he wrote the motion for Hawel and I also worked on it. And it was granted. Hawel is a Somali refugee who experienced a great deal of trauma in several different war zones before arriving in the US. She was trying to help other Somali refugees and got caught up in a material support case. And she got out a year early due to our compassionate release motion. There are several other so-called terrorism cases where compassionate release has been granted due to the risk from COVID. There's Wessam Al-Hanafi, a man we support who was serving a 15-year sentence for material support. He was released after serving less than half of that sentence. And then later his co-defendant, Sabaran Hassanov, who's also on our Ramadan list, was granted release also. Yasin Arif's co-defendant, Mohammed Hussein, was granted compassionate release, although it happened just before he was going to get released anyway, but still got out a little bit early. Another prisoner we support, Tahuar Rana, also serving an unfair sentence in a material support sting case, was granted release. And then, kind of amazingly, Abdel Barry, who was actually convicted of involvement in the 1998 US Embassy bombings, he was granted compassionate release and deported to the UK in December 2020. And he was approaching his regular release date, but he got out early. And then in December, last December, another prisoner we support, Ardit Farizi, who is a computer hacker extradited from Malaysia and sentenced unfairly in a material support case, was granted compassionate release. And I'm not sure if he's been deported to Kosovo yet, but should be soon. Unfortunately, many of the motions were denied, and that's because the judges, they have so much discretion. Some judges refuse to grant them in even really strong, compelling cases, while others are willing to grant them even in less sympathetic cases because they're more concerned about what will happen if the person contracts the virus. Now the window for filing these motions based on the risk from COVID is kind of starting to close because BOP is starting to vaccinate the vulnerable inmates, but that'll still take a while, and we still hope to file a couple more motions before the judges just say, no, they all have the vaccine now. And also, we plan to file compassionate release motions coming up soon in the case of the Newburgh Four, at least 3 of them, David Williams, whose aunt, Kiki, was on earlier with our family conference, and 2 of those co-defendants in that case, because in that case, they got a mandatory minimum sentence of 25 years. The judge had no discretion to give them less than that, and she made it clear that she was unhappy with that. So we think that she's likely, hopefully, to give them less time now and maybe even give them time served because they've been locked up for quite a while. So I'm gonna stop there. I think I took a long time, and we will move on. I think if you have questions, put them in the chat, but we'll move on to Molly and then Steve. Thank you.
Thank you, Kathy. Yes, so if we could move on to Molly, if you could tell us a little bit more about FAMM and what your organization is doing in this area of criminal justice reform.
Thank you so much for including me in today's event. I appreciate it. And it sounds like you are doing hard and good work on behalf of many individuals who need it. So that's very inspiring to me. And I'm always inspired by people who are working for those who are unpopular. Certainly all people convicted of crimes are unpopular and all prisoners are unpopular, but you are working on sounds like a subset of people who are especially unpopular, and that is difficult work. So thank you for being willing to represent them and advocate for their rights in court. So FAMM is a national nonprofit, nonpartisan organization. We've been around 30 years. This is our 30th anniversary. And during those years, we've spent a lot of time working in Congress on federal sentencing reform primarily, also on compassionate release reform, on making improvements to the federal sentencing guidelines, and then also advocating for greater use of clemency by the president. We also work at the state level and are increasingly doing more work at the state level. So this year we're working in Virginia, Florida, Arizona, and Pennsylvania, 4 very tough states to work in. Purple states, but Republican legislatures, and states that have, unfortunately, terrible sentencing laws that need a lot of improvement. So I sort of oversee all of our policy work and our policy team. I was our primary federal lobbyist on Capitol Hill from 2002 until really about early 2019. I worked extensively on the First Step Act with members of Congress and their staff members, and took a hand in editing and drafting some parts of the bill, including the compassionate release reforms. I'm very proud of those reforms, actually, and very happy with them, because one of the things that frustrated me so much in my time working at FAMM was getting phone calls from family members who had just found out, usually from a hospital chaplain or a prison chaplain, that their loved one was horribly ill, had been taken to a hospital. They weren't told where they weren't allowed to go visit them. And the person was usually, so close to death that the family often never got to see their loved one before they passed. And the compassionate release system at the federal level, as some of you know, it had been broken for a long time. Only the Bureau of Prisons could bring motions to let people out, and they basically never did that. And the First Step Act's major reform was allowing people to go straight to court when the BOP ignored them, which they usually do. So I do have some updated numbers about compassionate release grants. Just to keep things in perspective, in all of 2019, there were 145 compassionate releases. So that was after the passage of the First Step Act. 145 was an improvement over 2018 though, so starting to go up. And then in January and February of 2020, there were 21 grants only. And then since the beginning of COVID in March, 2,455 people have been granted compassionate release, which is an extraordinary number. So FAMM, as soon as the pandemic started, FAMM basically mobilized its network of pro bono attorneys, and we started the Compassionate Release Clearinghouse. We basically received petitions from people in prison, paired them up with attorneys who represented them, filed the court motions for them. A lot of people were denied, but obviously a lot of people were granted too. And so it was very exciting to hear those stories. And we have a lot of those on our website, which is famm.org, FAMM.org. And if you click on the stories tab, you can read a lot of these compassionate release stories. And of course, they're very moving. Many of the people who've been released on compassionate release are people who probably would have died in prison had they contracted COVID-19. Obviously, the pandemic is still raging, and there are unfortunately people still getting sick and in large numbers. So we're not anywhere close to being out of the woods yet. But I do think none of that would have been possible without the reforms in the 2018 First Step Act. So thank you for supporting that bill and making that happen. There have been a lot of other people released under the First Step Act, fortunately, and I'll just share some of those numbers with you. The First Step Act included a bunch of sentencing reforms, as well as sort of creating a new system under which people can earn time off their sentences for completing rehabilitative programs. Again, that was created at the end of 2018. And basically, there was sort of a 2-year timeline for Congress to implement it. Unfortunately, only one of the sentencing reforms was retroactive, and that involved the changes to mandatory minimum sentences for crack cocaine offenses. As some of you may know, for a long time, there was a significant sentencing disparity between crack and powder cocaine. Essentially, you got a lot more crack and you got the same punishment as someone who had a lot less powder. And that was viewed as unfair, as well as racially discriminatory, because upwards of 80% of people convicted of crack cocaine offenses are Black. Congress narrowed that disparity from what was 100 times as much powder as crack to 18 times as much powder as crack. So in a bill called the Fair Sentencing Act of 2010, we sometimes call it the Slightly Fairer Sentencing Act of 2010, because there shouldn't be any disparity between crack and powder cocaine at all. They're the same drug. And then, so that passed in 2010, and unfortunately, it was not made retroactive in 2010. So for 8 years, a bunch of people sat in prison who should have probably gone home and couldn't, because that law was not made retroactive. The First Step Act made that reform retroactive. And to date, well, I should say as of October 2020, so these numbers might be a little bit old now, there have been almost 3,400 people, 3,363 people who've received sentence reductions. They were allowed to go back to court, file a motion, request a sentence reduction. A lot of those people have been granted. More than 90% of them are Black. Most of them are men. And the average sentence reduction has been significant. Most people, the average sentence reduction is 70 months off the sentence. So these sentence reductions really are bringing people home significantly earlier than they otherwise would have been. Obviously, that's reuniting families, bringing parents back into their children's lives, bringing breadwinners back into the home. All of that is a positive development for these families, and I think for the communities that have been impacted as well. So I think what the First Step Act shows us is that we can pass sentencing reforms, we can make them retroactive. The sky doesn't fall. We haven't had some kind of massive nationwide crime wave since December 2018, fortunately. And I think that you know, what they also show people is that people grow and change when they're incarcerated. And maybe we don't need these long sentences to begin with. Maybe we can make our sentences much shorter. And the other thing is, maybe we can recognize that people have earned second chances and deserve a second look at their sentence. So I'm going to move now to talking about the new president and his criminal justice agenda that he's put forward, which you can find at his campaign website. And I'm going to talk about a little bit of the prospects in Congress, what the next couple of years might look like in terms of criminal justice and particularly sentencing reform. So President Biden has put forth an agenda that includes several racial justice components, probably the biggest of which is policing reform. I think he's very interested in trying to find some kind of bipartisan policing reform that can pass Congress. He's also interested in ending mandatory minimum sentences, and also there's interest in getting rid of the remaining crack powder disparity, taking that 18-to-1 disparity down to 1-to-1, treating those drugs equally for the first time since 1986. That's a reform that atFAMM is very interested in passing and supports as well. There's a bill that was introduced by Congressman Bobby Scott from Virginia called the Safe Justice Act that the Biden administration has endorsed. That bill was significantly broader than the First Step Act and was a bill that atFAMM supported. It did not have the support to get through Congress back in 2018. And now I'm not sure that it does now in a Democratic House either. But I think its odds are improved. That bill would essentially eliminate mandatory minimums by giving judges much more sentencing discretion than they currently have. It would limit the application of mandatory minimum drug sentences to basically very large scale drug operations, which would, I think, defederalize a lot of drug enforcement and move those cases into the state level. It would do a lot of other important reforms as well. So that bill is called the Safe Justice Act, if you want to dive into it in more detail. And like I said, we would support that as well. atFAMM's priorities for the new administration are going to be to end mandatory minimum sentences. I think there's also some interest in Congress in reviving what was called the Smarter Sentencing Act, which didn't eliminate mandatory minimum federal drug sentences, but cut them in half. So that would take 10 years down to 5, 5 down to 2.5. And it used to be life for a third drug offense. Now it's 25 years. Presumably it would take 25 down to 12.5. And we would support that as well, although we'd rather just see mandatory minimums eliminated at this point. We know everyone needs to be treated like an individual and deserves individualized justice. We also, like I said, we're supporting equalizing the drug weights between crack and powder cocaine, and then also making those other reforms, those other sentencing reforms in the First Step Act retroactive. As I mentioned, one of the most important reforms in my view was there was for a long time, a mandatory minimum life without parole sentence for a third federal drug offense. That is now 25 years under the First Step Act, but that change was not made retroactive. So you still have, several thousand people in federal prison serving life sentences for drug offenses, and they should not die in prison. So we hope very sincerely that those changes will be made retroactive. The First Step Act also included some changes to the gun possession felonies under the 924C statute that Kathy mentioned. Those have not been made retroactive, and we would support those. There are a lot of people serving those 924C sentences that are just serving ridiculously lengthy, absurd sentences. And then the other reform that atFAMM is supporting is a second look. And we just started our Second Chances campaign, which is going to be a nationwide ongoing campaign to create second look laws around the country. And we need one of those starting at the federal level. Fortunately, Senator Booker has introduced a bill that would allow a second look at sentences after a person has served 10 years. I think 10 years is probably too ambitious for Congress. It will probably be a larger number than that. But we do need a second look in the federal system as well as in most state systems. We have just put too many people in prison for too long. We need some way to get at these long, long sentences and give people those second chances that many of them have earned and deserve. And so we'll be supporting that all around the country. Let me just look through my notes here. I will say another area that we're supporting quite a bit is independent oversight of both federal and state prison systems. As I'm sure you know and have heard from people you correspond with, prison conditions have gotten worse than ever under COVID. They were bad before, and now COVID is just making them worse. And so one of the things we're advocating is the creation of independent prison ombuds who are not located within the Justice Department, who are not located within the governor's office or within the Department of Corrections at a state, but are fully independent, have the power to go in whenever they want, inspect prisons, talk to whoever they want, recommend reforms, get an action plan from the prison system about how they're going to fix the problems, follow up on that action plan, and again, keep communicating with the legislature, with the executive, with the public about what's really going on inside our prisons, because the conditions are unfortunately just appalling in so many places. Am I out of time, or should I keep going for just maybe a minute more? I just want to, maybe in the interest of talking about current affairs, I do want to say that one of the things that we are keeping an eye on in light of the riot that was at the US Capitol last week is, anytime someone wants to create a mandatory minimum or show that they're tough on crime, they want to create a mandatory minimum. And usually this is in response to the day's headlines. And so the headlines right now are all about this riot, and we call it the crime du jour effect. Whatever the big crime is that day, let's create a mandatory minimum and that will make it all go away. And we all know that that's baloney and nonsense and never works out the way everyone wants. And we end up putting a lot of people in prison who don't need to be there. We keep them there too long, taxpayers pay a huge fee for it, and none of us are made safer. So what we're seeing, unfortunately, in light of the riot last week is that there are states around the country that are proposing new mandatory minimum sentences for people who engage in protests and end up either sparking a riot, being part of a riot, committing violence during the protest. Tennessee passed a law like this at the end of last year. Unfortunately, we've seen some of these in Indiana. I think New York has one that's been proposed. And all I can say is we need to maintain constant vigilance. I can't condone anything that happened at the Capitol last week. I live about a mile from there and certainly did not like watching any of that. But I do not think mandatory minimum sentences are the solution to protests that turn violent. And I think that every individual who commits a crime needs to be treated like an individual. Not every person who protested at the Capitol is the same. Not every person who engages in a Black Lives Matter protest that turns violent is the same. And judges need to be able to make those important distinctions when they're sentencing people. So it's something to flag for all of us to keep an eye on for the future. And I'll turn it over now. Thanks.
Okay, thank you, Molly, for really good information. You all do such good work that we all appreciate it a lot. So I'm going to turn now to Steve. I'd like him to talk a little bit about some of our legislative objectives for the CCF.
Well, Molly, I really appreciated your talk, and certainly we support all that you're doing, and particularly with the mandatory minimums, that would be really important for our group and anything we can do to help you. I'm going to focus my talk today mostly on our EGO bill. That is the Entrapment and Governmental Overreach Relief Act, which we've called the EGO bill, which Kathy actually drafted as a way to perhaps bring some relief to the people in our group who've been preemptively prosecuted. I said if she would draft it up, I would get it passed. So she did that in about a month. I'm going to be spending the rest of my life trying to get this thing passed. But just to remind you all that includes 3 elements. The first element is to create for the first time an entrapment defense that can be used in when there are attempts made to do a sting or something like that. That provides for a requirement in all material support cases that of intent, that the person actually intended to support material terrorism. And the third thing is that to make sure that any classified information given to a judge during a trial is shared with a security cleared defense counsel. to prevent them from poisoning the mind of a judge with false security information. We think those are the three main ways or three key loopholes that we can close, which will prevent the FBI from essentially going after people for their ideology rather than for actually committing a crime. And so the question really comes up is what good news can, what hopeful trends can we find in the legislature that will permit the passage of this bill that is going to try to clip the wings of the FBI, bring them back to law enforcement rather than predicting who might commit a crime. So the good news is that Biden won the election. That's very important. And moreover, the Dems took the to runoff elections, so we now control Congress. And so that will prevent, presumably, a lot of bad legislation being anything put forth by the Republicans from getting passed. It unfortunately does not guarantee that anything that the Democrats want to pass is going to get through Congress. There's a filibuster rule. They could eliminate that and just do it on a majority vote, but Manchin of West Virginia has said he will not vote in favor of that. And so it looks like we're going to be living under the rules where major legislative initiatives are going to need a supermajority in the Senate. And so probably none of that's going to, it will be, things will pass, but only with the bipartisan support. So the good news then is Biden actually has a legislative plan for criminal justice reform, and Molly described that in some detail. All of that's really good. It's going to be perhaps a bit of a struggle to get it through Congress. I don't know if Molly has an opinion now how easy this is going to get through Congress. No, all right.
Not
I thought the same. And that also suggests that it will be very difficult to get an ego bill through at this point, because that is a little bit more controversial. It involves national security. It's a bill by itself. And I just see with all the other priorities that Biden is going to be dealing with, it's going to be really hard to get this one through. So anyway, it doesn't look like that's going to have a lot of problems, so a lot of priority. So the conclusion that I would draw from this is that in trying to get our ego bill passed, we really have to do what we've been doing for the last 2 years. And what we did initially was just try to go down to Congress and get as many Congress folks as possible to be acquainted with the bill. And we actually went down and we probably met with over, at this point, 70 or more different offices, different legislators down there, and talked to them in person about the bill. And we were quite pleased and surprised to find that there was a general positive reception, both by Republicans and Democrats, to the idea of the bill. Once they talked it through, they got it and they understood it. We were going to go back this spring in the spring of 2020 and really press hard to see if we can get more traction. And then COVID hit, and we got bogged down with COVID. And so then by the time we began to work our way around that, we got into election season and nobody was listening. They were all tied up with the issues during the election. So now that we've passed over beyond the election and we're looking at what's coming up in the next 2 years, it seems likely that things are not going to be all that much better even with the Democrats, because they'll be tied up with their own issues getting things passed. And so I think we'll just have to go back to going to virtually lobbying Congress, trying to get as many legislators as possible to understand the bill and see why it's necessary, and wait for an opportunity, an opening to come when we can get it passed. There is one opening that might suddenly appear in a rather dramatic way. And that is that if, as a result of the insurrection at the Capitol, the Biden administration decides that they want to pass a domestic terrorism law, this would be a major problem. As you know, most of preemptive prosecutions are conducted or carried out because we have a foreign designated terrorist act That is to say, people are connected up with foreign designated terrorist organizations, and then they claim that they gave material support to these foreign organizations. So and there's a whole bunch of Hamas, for example, foreign designated terrorist organizations. So if you contribute to Hamas, you'll be charged with material support. We don't have a domestic terrorism law, so that, for example, you can contribute all you want to the Ku Klux Klan or other domestic terrorist organizations, and that's fine. Nobody's going to complain about it. So because of the right's assault on the Capitol, there is some idea of maybe we should have a domestic terrorism law, which will then allow the government to go after all of these bad actors, so to speak, and lock them up. And from a gut point of view, there's a certain appeal to that. I mean, if they've been going after the people, the good people on the left all these decades, why not go after the bad actors on the right? And I think we have to resist that with all that we have, because there is plenty of laws on the books right now to handle any problems that are going to come out of the Capitol. These are actual crimes that were committed. There's no reason why they can't be handled perfectly well by existing laws. And in fact, the FBI has been doing exactly that. What the domestic terrorism law would really do would give the FBI a chance to go after even more ideology, to try to predict more what people would be doing and open the door to more entrapments and more of the kind of things that we've seen. And that inevitably will warp away from focus on the right to the white nationals and back onto people, black folks, and marginalized groups. And it'll be those ideologies in the end that will be targeted. So I think if this bill is proposed, we should oppose it. And I already have seen in the literature, in the various groups that are now speaking out, the ACLU has come out against it. I think Brennan Center has come out against it. There's a number of other groups that are already trying to oppose this thing. And I think that there will be quite a large number of other groups that will oppose it. But it's something that we can be concerned about. And one of the things that may happen is that it will put the ego bill front and center, because that is the alternative to a domestic terrorism law. What we are saying is, don't put a domestic terrorism law, is we go back to law enforcement, get rid of the foreign terrorist law also, repeal the Patriot Act, put something in here that will keep the ego, put ego would be in there to control the FBI and force them to redirect their attentions onto law enforcement rather than prevention. Oddly enough, if we were to push that, and if that became a focus, we would probably get quite a bit of support from the right. We would be working together with a group of maybe rather strange bedfellows. And it's an odd position. I don't know how I would feel standing next to Ted Cruz and other people that I could name or I could think of to defend or to push for an ego type bill and to oppose the domestic terrorism law. But I think it's a principled thing to do. And I think that in the long run, it is really important that we do that. So I hope if anybody feels uncomfortable about joining the right in support in objecting to a domestic terrorism law, that we talk it out now during the question and answer afterwards. I think as an organization, we need to be united on this and understand clearly why we're going to do this and what our motivations are. And I just want to mention finally, one thing is that the ego bill is really important, because among other things, if we could pass that, it would change the law with respect to a lot of the people, the reasons why a lot of our folks are in jail. And it would allow them to bring their cases back into court and have them reevaluated in terms of the light of the new standard. And given the way the courts are drifting now, I'm hoping a number of people could get out as a result of that. So this is probably for some of our people the best chance that they will have of getting out of jail, particularly those who are serving life sentences. So I will stop there, and maybe we have some questions.
Yeah, thank you. Just remember, if you have questions, you can submit them in the chat. And I don't see any so far, but
I have a
Kathy?
couple things to respond, but did you check the Facebook chat too and see if there's any there? I don't know, but I just wanted to say thank you, Molly. That was great, and Steve. And I think for our purposes, out of the things you talked about, Molly, for our cases, the one that would get rid of the mandatory minimums, hopefully it wouldn't exclude our cases from it. And the Second Look Act would also be really huge for our people, because many of our people have served more than 20 years even, or certainly more than 10 or 15 years. And for them to be able to come back, it's sort of like what we're doing with the compassionate release motions, where the judge has discretion to look at it, and it's a different standard. But anyway, that would be great for our people. And Steve, as far as wanting to work with the right or Republicans, I mean, that's what happened with the First Step Act. That's how we got the First Step Act, right? Molly knows a lot more about it, and I want to thank you so much for drafting that compassionate release part. That was amazing, and amazing timing too. So thank you. That's
yeah, I didn't know we were going to have a pandemic.
Right.
So
Good timing, but nothing was passing when it passed, right? Nothing, because Congress was at loggerheads and there was nothing bipartisan happening, except for this bill was like the only thing that passed, and it was bipartisan. There is support from the Republicans for criminal justice reform. Hopefully there still is. Maybe you know more about what's happening now, but there was then.
yeah, it's difficult to predict how strong bipartisan support for criminal justice reform will remain. I think it probably will help that President Trump will no longer be our president, and some of the messaging that he's used around law and order and American carnage, hopefully we won't be hearing that, certainly from the White House. I will say there do seem to be a few senators who are ready to pick up that mantle, including Senator Ted Cruz, Senator Josh Hawley. They're using some of that language. And then I think also what happens with crime rates is going to be very important. If in several major cities, murders are going up. That's usually the crime statistic most people point to when they say there's a new crime uptick, and that could really hinder the chances of future reforms passing as well. I think with all of the reforms, and we saw this in the First Step Act as well, the challenge is always going to be who gets the benefit, who do these reforms apply to? And what we saw in the First Step Act was very limited to drug sentences. That does seem to be where most of the energy and interest is, in repealing mandatory minimums. I don't hear people talking about repealing terrorism mandatory minimums, or mandatory at the state level mandatory minimums for violent offenses. It does seem like the focus is still mainly on the non-violent crimes. I think with second look reforms, proposing those, I think that's going to be the challenge there as well, as people are going to want to carve out, most of the people probably doing these very long sentences. And so, those fights are going to be difficult. I think right now, something like second look probably doesn't have bipartisan support, if it's applying to violent offenders, or people convicted of violent offenses, because they're not all necessarily violent offenders. So I do think that's a longer term project, and I think there's a lot of education that has to be done among the public and among lawmakers. Sometimes even from our own members, we hear things like, well, my loved one shouldn't be doing this time. It's not like he killed somebody. It's not like he did X. It's not like he robbed someone at gunpoint. So even among some of our own members, sometimes there's still resistance to this idea that if you commit a violent offense, maybe someday you do deserve a second look. So I think that's going to be a longer term campaign. In terms of working with bipartisan partners and working with the right, I will say that it can be done. It was done with the First Step Act. And I think that is one of the beautiful things about criminal justice reform, is that it can be bipartisan. we all share values of wanting to be safe and wanting a justice system that's fair. That is a universal American value. So I think it can be done. I hope the bipartisan cooperation holds, and that people don't retreat to sort of the 1980s rhetoric over the next couple of years.
I would just like to add to that, I completely agree with you that Thomas Massey and Tulsi Gabbard, conservative Republican and conservative Democrat, really, I guess you could say, have gotten together and I understand are offering a bill to repeal the Patriot Act. Something I think we could easily support. That would be right in our wheelhouse, and maybe we can find more if that bill starts to develop any legs. Maybe that would be a way to also start to approach some of our concerns about a terrorism, domestic terrorism bill.
Another question in the chat. If the proposed bill by CCF is a hard pill to swallow, why not amend the current laws? Anybody like to address that?
Two parts of our bill do amend current laws. They amend the material support law to require an intent to support violence, which is something that the ACLU pushed for. But then that was years ago in 2010, and it didn't go anywhere. The other part about classified evidence, that's also amending existing laws, basically just to say that it needs to be provided to the defense attorney with the security clearance. It sounds like a no-brainer. You have the right to confront evidence against you, but that's not how it is now. The only part that's not in current law is the entrapment defense, because there is no statute, there is no law that's been passed by Congress to provide an entrapment defense. It's come out through judges' decisions, through case law. And right now it pretty much doesn't exist. Nobody in our cases has ever won on entrapment, even though there's been very classic entrapment. Sometimes people that back out until they're offered $500,000 and then they come back. I mean, that's kind of the definition of entrapment. But the way the judge tells the jury now is if they didn't then back out of the plot, it's considered a ready response and they're still guilty. So there kind of is no entrapment defense right now. So we wanted to say, in order for them to go after somebody and try to manipulate them and offer them money and incite them with showing them videos of atrocities, and these are all the things that the FBI does and the informants do, is that they have to have been taking substantial steps toward committing an offense to begin with, not just things that are speech, just that are totally vague and they weren't going to do anything. And so that would be changing the law, but there's no way to amend a current law to create an entrapment defense because there is no current law on an entrapment defense. So that's my response to that question.
Thank you, Kathy. I have another question here. Going back to the discussion about compassionate release, do you see it becoming more difficult to get that in light of the vaccines supposedly coming online?
Yeah, we are already seeing this, that people are being sort of put in this catch-22 and asking their lawyers, I'm being told the vaccine's available to me. I'm also very sick and I have a compassionate release petition pending. What should I do? And generally, I think what we're telling lawyers and what lawyers are advising their clients is to take the vaccine and to look after their health first and foremost, and try to keep themselves safe. But it is an issue. And certainly I think as the vaccine gets administered more widely in the prison system, and especially to high-risk communities in medical facilities, we could see perhaps more reluctance to grant compassionate release. I hope that doesn't happen. I think the extraordinary and compelling circumstances language in the compassionate release statute still allows judges to grant compassionate release for reasons that aren't specifically COVID related. If you're 65 and you have cancer, who cares if you got, the vaccine? Why are you in prison? If you're not a public safety threat, if you've got a family who can care for you, if you're not a public safety threat, if you've got a good prison disciplinary record, that's, to me, that seems to make a fairly compelling case that extraordinary and compelling circumstances still warrant your release. And so I'm hopeful that even as the vaccine is administered more widely, judges will not shy away from granting compassionate release, but time will tell.
Yeah, thank you. And I would add to that that there have been some good appeal decisions saying that, yes, extraordinary, without getting into the weeds of it, that yes, extraordinary and compelling reasons mean basically whatever the judge sees as extraordinary and compelling reasons. So if the lawyer can make a good case for that and you have, a judge who agrees, then it can be for anything.
Yeah, we've seen some interesting case law developing as well around using the extraordinary and compelling reasons criteria simply to reverse excessive sentences in several 924C cases. And that's still going to be fleshed out in the courts, and we'll see how sort of widespread that interpretation becomes. But it's a very interesting development, the idea that simply the fact that the sentence is extraordinarily long, perhaps the law has been changed, perhaps this person has shown extraordinary change, all combined, that might be an extraordinary compelling circumstance in itself to readjust a sentence. And that's an exciting thread of case law that we're seeing.
I'm not seeing any more questions right now. And we're about out of time. Would you like to give some final thoughts?
Just that's kind of what we're looking to do for the Newburgh 4, is to argue extraordinary and compelling reasons, which I think the judge would be sympathetic to. It was it was the classic entrapment case where they still got convicted and then had a mandatory minimum sentence. So we're hoping to go back in and hopefully get them released, or at least a much shorter sentence. And then we're going to look for other opportunities under this law too, and of course look for all the other opportunities that we hope will be coming in the future.
I'd just like to say that I'm hoping that we'll be able to mobilize our army of impacted family members to go out and contact their congressional leaders and representatives and tell them their story. We know how the importance of stories, the impact of stories, and you have stories that make an impact. So you have to get out there and talk to your representatives, and that way you will spread it. I know that I went up and spent a lot of time on Capitol Hill talking. In every office that you visited, people remembered it, and they said, "Oh yeah, we had those families in there. I didn't realize any of that stuff. That's amazing. Those are really good stories." So we got to keep that up and go out there and spread the word, because we really want to get the ego bill passed, and now even more in light of the danger that they may be trying to start a domestic terrorism law, which would really cause a problem.
I guess there was a question about how to tell your stories and how to get your stories to Congress. And I would just encourage people, one place to start might be to go to our stories page and read some of the stories there at, again, our website is FAMM.org, FAMM.org. Click on the stories tab and you can see sort of how we tell stories, and you can read those, think about the stories that you have to tell. I think certainly humanizing folks who are in the criminal justice system is very effective. It's what FAMM has been doing for 30 years. And it is what lawmakers remember. They don't remember me, but they remember families. So I do encourage you guys to think long and hard and about how can you tell your story in a compelling way. And I understand some people here might have a loved one who's serving some prison time for an offense that is not sympathetic, that on first blush does not seem like something any congressperson wants to touch. So for those folks, I would encourage you to think about focusing on the family impact. We do that as well. We have some folks who have committed things that are not particularly sympathetic, but we focus on, this is, my loved one, he did this thing, or he's been convicted for this thing, but this is how it's impacting our family. This is the hardship we're facing. And, when we lose this person for a decade, this is what it means to us. So I think lawmakers are sometimes more willing to listen to a family perspective and understand that the family impact is so harsh, even if they can't identify or find sympathy in the person who committed the crime or was convicted of the crime.
This other question was in chat, and it's been entered in chat, but let me just put it out there. It's, would working to stop the terrorism enhancement also help?
And yeah, I answered it in the chat, saying that getting rid of the terrorism sentencing enhancement would help our people a lot. but it's kind of a complicated thing because it came out of the Sentencing Commission. It's a part of the sentencing guidelines. And right now that's not even functioning because they don't have all their members. I think Congress could pass a bill to deal with it too, but I think it might be difficult to make. Well, if we made a good case for that, maybe we could add that to the EGO bill or look for opportunities to do that, because I think Congress can pass things that affect the Sentencing Commission too. They've done that before. I mean, they control the laws. But it's kind of a complicated, difficult one, but it would help a lot. It's increased the sentences, kind of quadrupled the sentences in our cases pretty much, very unfairly.
Mhm. And then another question, what can we do to change or challenge or shorten the extraordinarily and disproportionately long probation sentencing, such as 30 years?
Can you take that, Molly, or the
A long
supervised
probation.
release? I think they're talking about supervised release.
Yeah.
Terms have gone up so high.
Yeah, supervised release is statutory, so unfortunately that's going to require legislative change from Congress. There is a move in the states right now to do probation reform. It's gotten traction in several states because the evidence shows that if you keep people on probation too long, they end up failing. And so it actually doesn't help people with reentry. It doesn't make it easier for them. It actually just ends up becoming something to trip them up later on. And what the data shows is that most recidivism is going to occur within the first 2 to 3 years. And so anything past that point is probably counterproductive and not increasing public safety. So some states are starting to look at this because states also have very long probation sentences, post-incarceration probation sentences. And they're talking about putting caps on those, limiting those. What we see there too is the same sort of carve outs. We will cap it for nonviolent folks, but if you committed a violent offense, we want to keep an eye on you longer. And what I've seen so far, we had a fight over this in Pennsylvania last year, is that is also actually a really difficult fight. And some of the opposition actually comes from judges too. Judges don't like to have their sentencing authority capped. They want to have that discretion to keep you on probation longer if they feel that that's necessary. So I think those are the challenges that would also exist at the federal level, but you're gonna have to talk about legislation, go to Congress for that.
Thank you. Okay, is there anything else anyone would like to add? Anyway, I want to thank, oh, wait a minute. Recently quoted the Second Circuit Court of Appeals citing that Congress believes that terrorism is different from other crimes and ordered a judge to resentence a man to a longer sentence than the 17 years he received. What's shocking is that there was no material support for terrorism crime committed, but it was clear that he attempted to stab an FBI agent while they raided his home, that he had mental health issues. How do we depoliticize this issue in Congress? Even though real crimes are not actually committed.
Good luck with trying to depoliticize things in Congress. That's where the heart of the beast is. That's all politics. I don't know.
Yeah, it's tough. We saw one good Second Circuit decision saying that might have been too long of a sentence in a terrorism case, and then this one with a different panel of judges saying it wasn't long enough. So it's tough.
Good stuff, yeah.
All the
Okay, well,
still going on.
I think we're about out of time, so I want to thank you, Kathy and Steve and Molly, especially thank you for joining us. We hope to see you again. I'd like to hear you play your violin next time.
Thank you for including me today. I appreciate it.
Thank you.
And also thank you to everybody who's watching on Facebook and YouTube. And we hope you join us again. So we will see you all next time.
Bye-bye.